Good evening, everyone, and welcome to another episode or installment of the Wednesday weekly webinar with the Property Law Alliance. As always, it's good to have you, Silna, as well as Bruno with us. Silna, you're sitting in such a lovely location. The view behind you is amazing. I'm glad that it looks like the weather in Johannesburg is a lot better. Is that true?
It really is better, and I'm so happy to be here. I'm in my office. This is how we know, the lawyers need some open space during the day. So I think like the view that you see is sort of where the thinking happens at SSLR. So I'm glad I can share the view. I'm glad you're enjoying it. The weather is actually quite miserable. Look at you now. You're opening the weather conversation. I didn't even. But the weather was actually quite miserable the whole time until Bruno, this afternoon, it was still cold and miserable this morning.
It's still quite overcast. I'm seeing the sun now for the first time in about a week. But yeah, it's still overcast. I wouldn't be surprised if
it's not overcast. Yeah, you're on the wrong side of Joburg. The West Rand is sunny, like it's nobody's business. So
the funny thing is, if I look outside my window, I'm looking at the West Rand, and that's where, like, I see a lot of sun. And then closer to me, yeah, it's still grey.
It's because I'm here.
So we need to be in the West Rand. Guys are saying we need to be in the West Rand. That's where we need to be. Or at least where Silna is, because it looks good outside. Which, interestingly enough, I'm at the coast right now, and with the whole lockdown being lifted, or at least some of the provisions of the lockdown being lifted, I finally get to go to the ocean. So now I've been here in Durban. I'm from Johannesburg. I've been here since the 28th of December, waiting patiently for Cyril Ramaphosa, our president, to say, yes, you can go to the beach. And now it's raining, so I can't even go even if I want to.
But you can drink beer. Okay, so you need to weigh these things up. Like, are we drinking beer or going to the beach? What's more important? I'm just saying, I don't have an answer. I'm just putting it out there.
We all know the answer.
I guess I could always YouTube a video of the ocean and the waves and just drink beer on the couch. Like, it works.
See, Chris, that's why I like you. You're a problem solver.
Guys, let's get into it. Today, we had a question in the group from one of the followers who had asked a question around a property that she wished to be bequeathed to her disabled son. The question was with regards to first of all, her son is disabled, and she wanted to know whether her bequeathing this property to her son would in any way affect any of the benefits that her son would receive. But I think more importantly, is she able to bequeath this to her son who is disabled? And is that son then able to have that property register onto his name? I don't know if, Bruno, you want to take this one or Solna?
I suppose I can start quickly. So from an inheritance perspective, you can bequeath your property to anyone. It's your decision if it's your property. So nothing can preclude you from doing that. Now, I suppose that the emphasis or the weight of the question comes behind whether the issue comes in the fact that the son is disabled. So the conversation around there needs to be what form of disablement, because if it is something that impacts a person's capacity to act, there are certain situations, for example, where a person would be declared, you're looking basically at saying of unsound mind or incapable of managing their own affairs. There's even things in our law where people can be declared as prodigals. All of this impacts capacity. And if your capacity is impacted, then the ownership of the property or the inheritance may become a bit problematic. But those situations are normally dealt with by seeking relief from the court and appointing a curator, for instance, to manage somebody's estate. Now, many of these situations are already preceded by the formation of some sort of special trust in favor of these persons anyway. So more often than not, you'll find that the bequest will go into the trust, which is already being managed on behalf of the individual. Insofar as the actual grant is concerned, I don't really have insights into the prerequisites behind social grants and at what point a grant will be disallowed based on income or asset value. I know income is a thing. I don't really know whether owning a house precludes someone from receiving a social grant, unfortunately.
Yeah, I agree
Thanks,
with you. I agree with you, Bruno, on everything you said, especially this the potential solution of doing a bequest to a trust. That's anyway what I would recommend in a situation like this, because it might be more valuable to have a trust that can then continue with that, either for him to reside in the property or to rent out for extra income. The truth is, if you do bequeath it to a trust, it resolves the issue also of the issue about the grant, because if there is, however, an actual payment then from the trust to the son, that obviously is directly seen as an income, which might impact the social grant there. But if it's simply for the purposes of him having to reside in the property, Bruno, I think you have a brilliant solution to bequeath to set up a trust. So don't do a mortis causa trust. So don't do a will that says once the mother passes away, there must be a trust registered. Do an inter vivos trust, which you set up while everybody is still alive and well, and then bequeath that property to the trust, or better yet, transfer the property into that trust while you are still alive and you know you are here to ensure that everything is done according to plan. I didn't even think of that, Bruno, until you said it, and it's the perfect solution for the entire situation.
And what's actually interesting,
Sure.
sorry, just to add on that, because you reminded me of something. So just two things. Our answer obviously is now assuming that the disability is something that's related to the brain or a capacity. So just bear in mind, if this disability is, inability to walk or whatever the case is, that's a completely different story. So there you can be an owner of the property. Impact on the social grants based on that, again, we're not 100% sure. Typically what I do say, however, if someone's relying on income from a property or residing on the property, use the trust, because there's a couple of great things behind it. And things, for example, like avoiding estate duty and deathbed costs, and even like using the conduit principle to apply the income through the trust without having to pay a higher tax rate. You can actually really save on paying tax if structured properly and legitimately. So it's something to consider depending on value. But yeah, that's my 2 cents worth.
I loved it. I loved the 2 cents because, Chris, I wonder if we shouldn't maybe jot this one down for a future more in-depth discussion around trusts and the use of trust in property, because I think every one of my clients that are currently watching, and I'm saying, oh, that's brilliant, Bruno, let's put the property in a trust, would now say, Silma, you always say never ever, property never ever in a trust. But I always say property never ever in a trust unless there's a few exceptions. And this is one of the exceptions. So I think it's actually a very good conversation for future reference. But I think in this particular situation, my advice for this particular viewer would be to consult with somebody that's actually going to be able to guide you around this. And in this particular situation, it might not be the typical law of succession, trust, wills and estates sort of attorney. Probably more likely Bruno Samau attorneys, SSLR type firm. It's more a property law question than just a pure law of succession sort of question. So I think that's it's a good advice. But if you don't do it right, it could end up causing more problems than solutions. And I think that's sort of the answer in law always, Bruno, right? The law applied incorrectly is usually way worse than just leaving it. So just do it right.
Yeah, absolutely. Yeah.
Oh, thank you so much, guys. That was actually, wow. You guys went a long way there in answering that question as well. So really appreciate that. As you do, yes. I just want to quickly move on to a scenario that I'm going to pose before the two of you. And this scenario is, let's say, for instance, myself, I decide to register on an online auction house, and I see a property. This is for the sale of immovable properties, and I see a property that I particularly like. So I start bidding on that property. I bid, and my bid is then successful at fall of the hammer. I subsequently then decide, oh, you know what? I really don't want to be bound by any of this. And I quickly make my intentions known that, look, I'm out. I'm out. Now, this is before I sign any conditions of sale, because that auction house will provide me with the documentation to sign. And I say, look, no, to hell with your documentation. I'm not going to sign anyway. This was just, it was fun for me while it lasted. I really like the feeling, and, it gives me a rush to bid at auctions, but haha, joke's on you. I'm not going to be part of this. So the way I want to frame it is, I want Bruno to please let us know what the rights of the auction house would be, and what legal recourse do they have. And then Silna, you would take the side of this this individual who is having a lot of fun on the auction house's online, on the online portal. So put your boxing gloves on, figuratively.
I need a glass of water for this one.
And I think let's start with Bruno on this, representing obviously the auction house. What recourse do they have in this particular instance?
So in Silna's defense, what you're going to find, unfortunately, what?
I haven't even started, Bruno. You're like arguing on my behalf, and I haven't even said a word. But thank you.
I think because of the experience, there's, and it's something that we say all the time. The reality is there's always like two versions in law. But what you tend to find is, once you're experienced in certain fields, you tend to find a pattern with some of the versions. And for example, you see it with sales and execution with sheriffs. And a lot of the times you're looking at a 90% chance that a lot of the people that are disputing whether the bank sold the property or the sheriff sold the property lawfully, 90% of the time, unfortunately, they don't succeed. For one reason or another. So you do, I suppose, here we start looking at trends. So the point that I was going to make, though, is the problem with property auctions and auction houses is you do tend to find there's a lot of one-sided behavior in it from a contractual perspective. So most of the arguments that are raised against the auction houses tend to be of a very contra bonus mores nature or constitutional nature, or something that actually deals with the fairness element to it or reasonableness element. And the reason I say this is, when you go into the auction, the first thing that you'll end up doing is paying a registration fee. Now, a registration fee is already money out of your pocket, which you can pretty much say goodbye to if something goes wrong. So this person having fun, depending on what the registration fee is, but the reality is they're not low fees. The fees are quite substantial sometimes. So, I mean, you're really going to be out of pocket trying to convince someone to pay that back. Now, obviously, the question's going to be around, but hold on, wait, I didn't sign anything. Why would I be out of pocket? I did nothing wrong. I didn't sign any deed of sale, and I know deeds of sales have to be signed because that's what Silna and Bruno tell me on a weekly basis. So, haha, I win this. The problem is, when it comes to auctions, this is well stated in our law, and the actual act of auctioning off the property does constitute the sale, provided that it is later recorded, right, in some sort of deed of alienation. And because of that, the reality is that actual bidding process is the offer and acceptance process, which is later put in writing and said to be a recording of the sale. So to that degree, you have bound yourself. You have actually concluded an agreement that they can actually go and enforce and say, listen, you do actually need to sign this contract because the agreement's already there. Now it's a matter of formalizing it and placing it on record. So that's the first thing that we need to consider. But now, do we even have to go that far? you've got the registration price that you've paid, which it's unlikely to be refunded. You've got the situation where you actually made the offer and it was accepted by the auctioneer. So that's now another problem that you have in law. So now the question comes in, what's the worst that could happen? And so I do tend to find that sellers typically don't go after purchasers very often because of the large sums of money required to enforce a sale and force someone to buy. But what I do find is that auctioneers and estate agents won't have a problem doing this, and rightfully so, if they've done their job. And you've now gone on an auction, you've bid, everyone's left the auction house or basically logged out of the online auction platform. You've now just caused a huge issue because the auction has been advertised for that day. There's a 3-week advertising period. There's a huge amount of costs incurred because, I mean, we're normally looking at about 15 to 20,000 Rand per auction that's spent on advertising. And it happens once. Now, to do it again, it's not just a matter of saying, don't stress, we'll do it again tomorrow. It's now the same process being followed again. And because that process is now implemented and put into place, damages are going to be suffered. The auctioneer is going to want his commission because if he doesn't sell this property again, there's going to be trouble. You may find that the seller might even sue you for the difference in purchase price, because if the property goes on auction again for a lower amount, they can come after you and say that that difference in purchase price is damages that have been suffered. The cost of advertising. So there's waste cost to consider. So there's quite a few things, and some of the amounts aren't that big, which means that people are willing to go after you because they figure they would be able to easily acquire it just by selling, a movable property and things like that. So yeah, the dangers are real when it comes to once you register, like, treat it properly, take it seriously. It's not something you can just back out of easily.
Okay, thanks, Bruno. Salah, we'll pass that ball over to you now, and let us know if there's any hope.
Luckily, Bruno already said in my defense. So the truth is, exactly what Bruno said is that is the position in law. The truth is, when you register for an auction, be it a sheriff auction, an insolvency sale, an auction where the parties just agree to take the property on auction, the owner decides he doesn't want to wait for 1 million people to come and view the property. He wants to do a once-off auction. The thing is, the moment you register for an auction and you pay the registration fee, you accept the terms and conditions of the auction. So what I find a lot of outliers doing is they will register, especially for online auctions, because for some reason, if it's virtual, people feel it's not that real. It's very real. And if you click the accept terms and conditions, you've accepted the terms and conditions. And in most auction houses and most auction situations, those terms and conditions are extremely in favor of the auction house. Unfortunately, at this stage in our law, there isn't really much law around justness and equitability and things like that governing auctions, which is something I would like to see. But I mean, it isn't at this stage. So the auction house has sort of free rein, and Bruno, as you rightly mentioned, you even called it contra boni mores. And the truth is, the fact that is a thing is actually quite sad, but still people do it. And like you rightly said, Chris, you get so excited at an auction. I'm, for instance, not even allowed to attend a sheriff's sale ever. My business partner holds onto the business card like a mad person. If he hears the word auction, he's like, Silna, you're staying at home that day. There's no way you're going, because you get so excited. It's so much fun to bid on something. But the problem is, when you register for an auction, you are in, and once you are the highest bidder, you are the one that won the bid, and you are then bound by everything you've agreed to at the registration process, which in most cases, if it's not, then I'm like, what were you thinking, auction house? The thing is, part of that would be, if you are the highest bidder, you will then be compelled to sign an agreement to give effect to the sale. Now, as much as I should make an argument here on behalf of a purchaser to get out of it, the only way of getting out of a sale like that is if you can demonstrate that there was some form of misrepresentation. So say, for instance, your terms and conditions and the marketing and stuff refer to property X, and you see you end up buying property Z. Okay, lekker. Then we have arguments for days because it's not the same thing that you agree to buy. Then I can get you out of it any day of the week. But if there isn't anything that's fraudulent or misrepresented or something like that, if your terms and conditions of your auction on registration compelled you to accept the offer and to make a formal offer and to accept transfer of the property, if you were the highest bidder, that's the way it is. But something that I want to caution people on that wasn't part of the question, but still I'm on the side of the person who is bidding, the excited hand raiser, is your bid and the fact that you're the highest bidder. As much as you have a bit of a gun to the head to accept transfer, there's a very good chance, not a very good chance, but almost equally good chance that you might not be able to buy the property. What I'm saying is, usually in your auction, in your conditions of sale, there is still, if it's not a forced auction, there's always a provision that says the owner has X amount of time, 48, 72, thereabout hours, to accept this offer. So the fact that you were the highest bidder on the auction does not necessarily mean that you are actually going to buy the property. The owner might come back and say, no, thank you, don't want to sell. I had a case like this about 5 years ago where my client purchased a property on auction. She was the highest bidder. And 3 weeks later, she received a notice to say, oopsie, we as the auction house did not inform the owner of that you were the highest bidder. And the owner does have the right, in terms of the auction house's mandate agreement, to accept or reject the highest bid. And my client was already, she put her property on the market because she thought she's going to move into this property. And she said, can't we go for specific performance? Isn't there anything where I can compel this owner to sell? And the answer is, depending on the mandate agreement between the owner and the auction house, and then also depending on the terms and conditions for registration on the auction, and also the conditions of sale. So I think what we're trying to say, Bruno, you're going to agree with me on this one. When you buy from an auction, be it a sheriff auction, so a forced auction, or an arranged auction, you need to be very cautious. At all the property shows, Bruno, I always enjoy this. I think that's where our friendship started, is actually at property shows where we share. We usually back to back on the auction theatre.
On the auction theatre, yeah.
On our talks around, you usually talk about what you should do in an auction, and I always talk about, oh my goodness, what you really shouldn't be doing and what you look out for in an auction. That's why we're such good friends. We like the yin and yang of evictions. And I think it's something very important to understand. If you don't understand auctions, like inside and out, you're potentially going to buy the mother of all cats in bags, which is cool if you're a cat person, but if you're not, it's...
So echoing what Silna said, and she actually makes a very good point. So like even our collaboration when it comes to auction theatres at property show, the content is just, it's crazy. Answering this one question now, as she spoke, I was like, oh yeah, and mention things like occupation. Oh, what about who's liable for the costs? How does, there's so many different elements to discuss that this one question is literally, it just touches, like it's just the tip of it. I think from an auction perspective, if we're actually going to give it attention, it's a solid like couple of hours chatting about breaking it down into smaller topics. But what Silna says is right. The problem is going into an auction. No one's saying be so scared that never go to auctions unless you've paid an attorney to give you a huge amount of education. I think just let the red flag kind of, pop up there where you say, listen, I'm going to an auction, but I've been warned that it's not always as simple as the movies make it out to be. So it might help looking at one of these videos or two of these videos, going to a couple of auctions, experiencing it, and understanding what it's about, chatting to a few guys before actually doing it. Because I think that's where the issue comes in. First timers who expect something and get more than what they expect.
I think,
Sure.
and Bruno, I think you're very accurate in that. I think it's actually a good thing to call for questions on the group around auctions. Not even just questions, maybe even like comment on this particular video around your experience, because I know a lot of my clients that makes beautiful money off auctions, but at the same time, I'm currently sitting with a matter that's heartbreaking. A client that purchased a property on auction, and the matter, we were just supposed to do the eviction. So just as we commenced eviction proceedings, the occupant of the property, being the previous owner of the property, suddenly said, no, I never gave mandate to the auction house. And we all like, huh? And he now brought an application to set the sale aside, which I think now is very relevant to tell everybody that will stay your eviction proceedings. And the court did actually stay eviction proceedings. So now the whole sale, validity of the sale is up in the air. And my client is now already being sued by the municipality for outstanding utilities because transfer took place, but we can't do the eviction, and the eviction is stayed pending the outcome of the dispute with regards to ownership. So I don't mean to scare anybody, but I do mean to ask for comments and stories and questions. And so we just opened that auction conversation a little more on this particular platform, so we can avoid heartbreaking stories like my client's situation.
It might not be a bad idea to actually do like a small little eviction series. Just break it down to like bite-sized episodes that focus almost entirely on it, that people can watch if wanting to go into an auction, and what you can control and what you can't control. That it might not be a bad idea to do that.
I like it, like a little auction series.
Yeah.
Definitely. No, thanks guys for that. So I think what we've gathered is that auctions are not as easy or simple as they look, but at the same time, with the right knowledge and with the right, I would say, tutoring or just insight into how it operates, one can really make the most of it. And I think also another thing that I learned is that it's not the best idea to be registering at an auction and then waving at your friend. Is that correct? Like, so just like, hey, like during the process. Like,
hello.
No.
You're gonna buy a property. I always, because we sometimes, this is a fun fact of lawyers, we sometimes have to attend auctions on behalf of our clients just to oversee the process or whatever. And I actually have an auction habit. I haven't been to an auction, like I rightly said, Nick, make sure I don't put my foot close to an auction. But I actually got into a habit of like sitting on my hands like this because I get so excited. But I think it's my personality type. I'm like, and then I have to remember not to raise my hand. But yeah, don't wave at friends.
No, thanks, guys. Thank you so much for that insight. I think we're quickly going to move on to a question here, which is something that's commonly asked, and I think we have dealt with it on prior webinars, but it would be good to delve into it again. And the question is around, I'm going to use myself again. I have a tenant in my property, and my tenant, is for some reason either being difficult or failing or refusing to pay the rent that's due on that property. As a landlord, am I entitled to terminate the electrical supply, or even for that matter, the supply of water to that property? And if I do so, is there any form of recourse that a tenant would have in this particular instance? I think we'll open the floor at Bruno or Silna, whoever wants to take on this question.
I think when it comes to spoliation, Bruno, luckily Chris, you can't even make Bruno and I argue this one because we're on the same page on this.
Yeah.
I think a good starting point would actually be current Regulation 38 of the lockdown regulations. So I think for our viewers' sake, I want to remind everybody that the law is usually one specific way, and then currently with lockdown regulations, there's a bunch of things that's different or new or apply differently than it usually is in normal life. So Regulation 38 actually does something quite special. It relates to the Rental Housing Act. So once again, for the benefit of the viewers, the Rental Housing Act only applies to residential properties. So not commercial, retail, industrial. It's only properties where you reside, rental housing. So you need a housing sort of element there. And what Regulation 38 says is if somebody is deprived of possession, be it by disconnection of utility supplies, by a lockout, by moving friends in to live with the people, any form of deprivation of the undisturbed use and enjoyment of the premises. And now I'm saying this in bold. Can you hear? I'm talking in all caps and bold and underlined. Even if that particular possession is unlawful and illegal. Can you hear? It's amazing there. I can actually hold my words. It's a special power. Even if the possession is illegal possession, you do have the right of protection from the Mandament van spolie, which is a Dutch term. It's not me just Afrikaansing it now. The Mandament van spolie allows a person that's been deprived of possession to approach a court to be placed back in possession. Now what Regulation 38 does is it gives the Rental Housing Tribunal the right to hear spoliation applications on an urgent basis, and it specifically says 24 hours. So a tenant or an illegal occupant, for that matter, that's been spoliated, your electricity was turned off, locks were changed, whatever the story is, you have the right to go to the Rental Housing Tribunal on an urgent basis to have an order to compel the landlord to restore your possession. If the tribunal doesn't give you joy, which may or may not happen, but should it happen that the tribunal doesn't hear your matter quick enough, you do have the right to go to a high court or a magistrate court for an urgent spoliation application. It's going to cost a pretty penny to go to the high court on an urgent basis, or even Madge. Personally, I won't even try an urgent application in Madge. The high courts are geared for urgent applications, and especially currently on case lines, it works like a charm. You can be, I mean, Bruno, if a client calls us now with a utility disconnection, we can theoretically, if urgency permits, we can be in court at around 10 tonight. Don't call us now with I'm busy on a webinar, but if it has to happen, we can be in court that quick. But the problem that we are actually faced with is, so the occupant that's been deprived of possession has rights a list as long as my arm, and I have pretty long arm. So, but the bigger problem is actually for the owner or the landlord, because what I see is owners, landlords try tricks to get the person out, and it never works, guys. Like, I mean, seriously, I've seen maybe 2 out of 10 matters where the person gets a skrik and he vacates. The rest of the time they Google, I have been locked out. And there are a million things that tells you that this is illegal, this is how you handle it. You can bring an urgent application without the assistance of an attorney. So for the person that's been deprived of possession, it's a relatively easy way to get back to being restored, your possession being restored. And the problem is, Bruno, I think you experienced the same thing. if you go to court with an eviction and you can stand in front of the judge and you can say, my poor client has followed the letter of the law, every single step of the way, they've been frustrated out of their minds because the sheriff doesn't serve on time, then the court file goes missing, and yet my client's been doing everything they possibly can to be law-abiding citizens. The judge is usually like, oh, shame, let's just help this poor guy. If the respondent, as the illegal occupant, walks into the same court and then says, my electricity was disconnected, then random person X moved in with me, I was so scared, they stole my stuff, the judge is going to be like, I'll still grant an eviction order, but I think, sir, you can have a good 3 months to vacate. It's not because the court is spiteful, it's because the court applies the law as we should.
Yeah, absolutely.
No.
And what's so interesting, so I'm unfortunately normally on the unfortunate side where or not unfortunate side, but the wrong side, where my clients are the ones doing this, like doing these acts. And what I actually found, I don't know if you experienced the same thing. So the extension of these powers to the Rental Housing Tribunal is actually, it is a good thing. I mean, it's something that should always be there. I mean, tenants need to know where to go. And it definitely takes a lot of pressure off the courts. What I did tend to find quite a lot of is the obtaining a spoliation order became so easy by using magistrates courts that we actually found that people were getting them barely doing anything. They used to go in without an attorney, some guy behind a counter handed over a piece of paper. Were you spoliated? Yes. What happened? I got home and it was locked. Order granted. And we actually got crazy orders granted where on our side, we weren't even given the opportunity. I mean, some of my clients actually didn't do anything. Sometimes it was access cards getting updated or something along those lines, like something legitimate that actually happened, and you'd end up with spoliation orders being granted. And I found that was a bit of an extreme on the other side. But the reality is that from a tenant right perspective, there is a level of protection. So from a landlord, like what Silna said, so she says 2 out of 10 times. I mean, I see 1 out of 10 times where there's success with this, because it's so easy to get a spoliation that very rare, and people know it. And when they go to magistrates courts, they've just been locked out. They've got no issue going to the magistrates courts, getting a stamp. And the worst part that you need to remember is it's counterintuitive because their stuff is in the property. So doing a lockout actually doesn't make sense because you're forcing them into the position where they need to do something. So that's actually not the right way to go about it. Not even from a lawfulness perspective, just from a intuition perspective. You're pushing them into a corner where you're forcing them to act. And from that day, everything's just going to become harder because then it becomes a question of principle. So I just noticed that you don't really get the results that you want as often as you'd want as a landlord by committing an act like that.
I have a fun electricity disconnection story. My client, well, now that you say your clients are only 1 in 10 lucky, mine are 2, like, are we saying my clients are luckier than yours? I'm just asking. I have the lucky client. It's like when you get 200 CVs for candidate attorneys, and you have to split the pack in half, and just say I only appoint lucky people. I don't really do that.
So remember, with the sales and execution, I think honestly that's actually where it throws that balance off. Sales and execution, there's already that emotional charge behind everything. So as soon as you go buy a property at a sheriff's auction and you go try lock out this person, sure, it's the end, because this person will fight tooth and nail. With tenants, you might find some go, it's just not worth it. You know what? Let me call them up. I'll take my stuff. I'll be out tomorrow. Sales and execution. Even if these people were thinking of getting out when the property was registered, you do something like that, you're almost guaranteeing out of principle they won't.
Exactly. And I once, on utility disconnection, I thought karma has a very interesting sense of humor, because my client disconnected electricity supply. And I told him to reconnect the electricity supply. It's illegal to do that. So reconnect, but as it goes, our clients, I know this might come as a surprise to many of our viewers, our clients doesn't always listen to our advice, but I suppose it's what doctors say about their clients that doesn't quit smoking, right? So it's not the same thing. So the next, like 2 days or something later, my client called me and he said, well, now we have a serious problem. I have my living room carpet is burned on a whole new level. And I said, yeah, what's the problem? So the tenant, it was in the winter, and the tenant decided, well, if I don't have electricity, I need some heat in the apartment. And he brought an actual traditional, I'm a farm girl, so the term conca makes a lot of sense for me. A conca is like a drum with holes that you make fire in. If you're not a farm girl, I'm sorry, you're going to have to Google conca. And the guy brought an actual proper real conca in. It was like a property in Sandton, and made like a fire in the house. So except for the carpet that was burned, I mean, that kind of smoke, like a fire. Also, the fact that nobody died is an absolute blessing. But the tenant messed up the property. And obviously, to try and go for a damages claim there is like, well, you sort of forced me to make a fire in the living room. And I'm like, yes. So I think the point of my story is don't take the law into your own hands.
Absolutely.
We have a legal system for a reason.
Yeah, absolutely.
Exactly.
And I mean, I often give this example. We had that one case where the person's heart medication was locked inside the house.
Oh my gosh. Sure.
So I mean, stuff like that's real, and
Yeah.
you've got no defense. So you could land up in massive trouble.
Yeah. And I'm assuming the same holds true for if I were not paying my rental, but I was a collector of expensive Wagyu steaks, and I had about 100 of them in my freezer, and you terminated the electric supply, would you more than likely be liable to pay for those as well in terms of damages? If I could prove that So you just never know what you're going to
get. A collector of Wagyu steaks. Chris, I love your examples. I wouldn't have even thought that's an option.
I'm quite a refined gentleman, you know. Okay. Thanks so much for that, guys. I think that was a really in-depth look into something that we have discussed before, but I think, wow, like really good look into that. I've got a final question here, and I'm going to be using myself again as an example. I'm starting to think I have a lot of legal problems, but
free advice.
I think it's using us, Bruno. It's like the third week, and I'm getting a feeling that we're being used. It's fine, Chris. You have good questions. Use us.
So I buy a property, and I am instructed by my conveyancing, or the conveyancing attorney rather, to transfer my deposit into their trust account. Now, the particular trust account earns a certain amount of interest at a specific percentage. And I'm like, no, that's a bit low. I actually, with my banking or financial institution, I earn a little bit of a greater amount in terms of the interest that will accrue on this deposit. Do I have the option of investing my money elsewhere, not with the conveyancer? And what will the process involve in terms of me doing that? I think maybe Solna, you want to have a dig at this one quickly?
Yes, well, at this stage, luckily, I think with interest rates, if you say higher interest rate instead of 3.4%, you can maybe get 3.42%. That's sort of higher that we are talking about at this stage. But I see that often in our conveyancing department, definitely. Remember, in terms of Section 78, capital A, the money in an attorney's trust account can be invested with the interest to accrue to the owner of the money, so the purchaser in this particular situation. Interest rates, depending on who you invest with, is higher or lower. The truth is, in most cases, I think as attorneys, we actually get nice high interest rates because we don't bank with we don't invest with just average banks, and we get special rates because we tend to invest high amounts for longer time periods as conveyancing firms. But this will depend on the offer to purchase. So once the offer to purchase is signed and the offer to purchase says the deposit must be paid into the attorney's trust account, into the conveyancer's trust account. That's the only place it can go unless there is an addendum to the offer to purchase signed to dictate something differently. So I recently had a matter like that. One of my clients actually wanted to sell her property. The purchaser agreed to a recourse. Oh my goodness, we need to get into recourse one day as well. Recourse meaning that the deposit that's being paid, if the sale does not go through and transfer doesn't go through, the seller can retain that amount of money. So the particular amount was 450,000 Rand. The purchaser's father is a conveyancer. So he said, obviously, his dad will do his transfer for free. He's the purchaser, so he has to pay the transfer fees. And my advice was just agree in the offer to purchase that the money will be paid into my trust account, even though another firm is attending to the transfer. No problem with that. But it has to be agreed to in terms of the offer to purchase. If the offer to purchase says conveyancer's trust account, has to be conveyancer's trust account.
Sure.
Absolutely. So it's quite interesting when it comes to the payment of deposits, and especially the application of recourse, but that will be for another day. Insofar as the deposits and investments are concerned, we had a case recently that kind of spoke about this, where the contractor said, look, pay the deposit to the conveyancers. And the conveyancers were supposed to hold the deposit in trust. Now, in this specific instance, the purchaser went to the conveyancer and asked them and said, listen, do you mind giving me the money back? I want to deposit it somewhere else at a higher interest rate. And this again goes back down to make sure that everything is contracted for properly. In this case, the conveyancer was negligent because he gave the money back, allowed the person to invest somewhere else, the transfer registered, and now the purchaser didn't pay the money, it didn't pay the deposit back. So the seller was fuming at this. But I've seen this happen with sellers as well, where they don't realize the implications. The reality is, why do conveyancers hold the money, or why do estate agents hold the money? It's to keep control of this money. When we hold it, it's what like you typically refer to as escrow. It basically sits in a safe place that, and payment in terms of which are well defined. So this money will be released upon X, Y, and Z. And as an attorney, we're supposed to be independent, and we will only pay it under those circumstances. As on Solna's example, it does speak to the fact that the reality is, yes, we are attorneys, but attorneys also represent certain clients. So in that instance, you'll see that the reason why Solna wanted to hang on to the money is because recourse sometimes is just thrown around, and everyone, oh, recourse this and recourse that. Half the people don't even realize that recourse doesn't apply to at least 50% of the situations. So what you don't want is an attorney that's leaning more towards one person than the other. And so I suppose that's that fine balance. So if you have a relationship with a conveyancer, rely on them when it comes to things like this, because the money's there, it's safe. And a professional conveyancer would actually deal with it correctly. I'd be very careful with recourse and giving the money over, because I have seen some conveyancers not act 100% the way that they should act.
Mm-hmm. And I think to your point, Bruno, of your story, where the conveyancer released the money, the truth is, the conveyancer effectively acts on behalf of the seller because he is transferring on the seller's instruction. So whether the purchaser appoints him or the seller, effectively, a conveyancer does something on behalf of a seller. So the problem with your situation is, obviously, I mean, that conveyancer was absolutely negligent on a whole new level, because you are releasing money that your client's entitled to his detriment. My advice always on conveyancers, we both do conveyancing as well, so we know exactly what we're talking about, is as much as you will ask an estate agent for his fidelity fund certificate, you're entitled to ask for the attorney, and you're entitled to ask the attorney to even for feedback on their trust audits. Have they ever had like an issue on a trust audit? We all do everywhere. There will be issues on trust audits if you are honest and open about mistakes that are made, things like that. You need to be aware of that, and you need to know that the conveyancer that you are trusting to transfer your property is willing to be honest and can show that they pass their trust audits every single year, because otherwise you end up, and I won't say names, but unfortunately we've all seen firms, a recent neighbor in Roodepoort, not recent, but about 5 years ago, with 47 million rand out of his trust account, and then he passed away, and there isn't, clients aren't going to get the money back. So to trust your conveyancer and to appreciate that they have measures in place when it comes to managing the trust money is as important as it is to ask your estate agent for Fidelity Fund certificate. Go Sherlock Holmes on your attorney.
Yeah, fair enough.
Thank you, Bruno. Thank you, Silna, so much. This has been such an insightful addition to the Wednesday webinar. And thank you again just for the time and the effort. And I just want to implore our viewers to please post your questions in the group. That's the Property Law Alliance group. And we'll raise them up in these conversations. And as you can tell, we really go in depth in a long way to addressing your legal concerns. So I just want to thank you guys again. And hopefully the weather, Bruno, on your end gets a little bit brighter. And hopefully I get to go to the beach soon. And Silna, you just keep enjoying that view behind you. So envious.
Thank you. Can I go home, though? I mean, I love my office, but I don't necessarily love staying here far past 7 in the evenings.
No, so guys, thank you so much. Please tune in next week, Wednesday, for another edition to the Wednesday webinar. And yes, looking forward to seeing you guys then. Everyone, goodbye and thank you. Bye, Bruno.
Thanks.
Bye, Silna.
Thanks. Cheers, guys.
Bye-bye, everyone.